Imagine this. Someone confesses to, well, a kind of murder. Not of a person, but of a dream. A massive, towering dream of steel and glass that was meant to scrape the Hong Kong sky.
Yeah, it's quite a dramatic setup. We're talking about a skyscraper that never actually happened.
Exactly. And today, we're diving deep into this story, a real clash between huge ambition and these hidden roadblocks in Hong Kong, all unfolding in the run-up to the 1997 handover.
It's fascinating stuff. Forget your typical true crime. This is about high-stakes land deals, legal fights, and that tension in the air as Hong Kong faced this massive change.
So this is the deep dive. We've got the court documents here, the official judgments involving Yingho Company Limited and others versus the Secretary for Justice. We're going to unpack it all for you.
Right, think of it as your shortcut to understanding a really complex but important story about development and law.
Okay, so let's set the scene. You've got this group of developers in Hong Kong, full of that, real go-getter attitude. They dream up this plan, the world's tallest building in Tsuen Wan.
And it wasn't just about building something tall. It was meant to be this huge symbol, a statement of confidence in Hong Kong's future, right as things were about to change significantly.
But then reality hits. Their sky-high dream runs into a very grounded problem. The new Cheklap Kok Airport, which was under construction at the time, it was about, 18 kilometers away?
Yeah, something like that. And the big issue, the potential snag, was the building's height interfering with the airport's instrument landing system, the ILS.
Ah, the ILS. Crucial for landings, especially in bad weather, right?
Absolutely critical for safety and efficiency. So you immediately see this tension, the developer's powerful drive versus the practical needs of this massive new airport.
And we'll get into how they try to solve this, but spoiler alert, they couldn't meet a key deadline in their government land lease. A building covenant, it's called.
Which could have meant losing the land entirely. So to avoid that, they paid a huge sum, over $500 million Hong Kong dollars, for an exemption and damages.
Wow, $500 million.
But, and this is crucial, they paid it under protest. They didn't agree they actually owed it.
Which naturally led to a lawsuit. They wanted that money back, plus damages, arguing they'd been treated unfairly. A legal fight that went all the way to the top court in Hong Kong.
After losing in the lower courts, yeah. It shows how much was at stake for them.
So that's our mission for this deep dive. Really dig into this core conflict, the developer's massive vision versus the rules and regulations, especially around building height and keeping planes safe. We'll look at the arguments, how the judges saw it, and, the underlying pressures of that time.
That central conflict is just so compelling. You have this, internal fire from the developers, this massive ambition to build a record breaker, a symbol for post-handover Hong Kong.
Totally. It's like shouting, "We believe," from the rooftops or where the rooftops would have been. But then comes the external wall, the unexpected hurdle, the airport's landing system.
It's a classic story, really. Big dreams hitting hard constraints. And the stakes couldn't be much higher.
Now, the government had a specific tool they used here, right? Something in the land agreement.
Yes, a really critical piece of the puzzle. The Design, Distribution, and Height Clause, the DDH clause. It was part of the land grant conditions, Special Condition 9E specifically.
Okay, DDH clause. Break that down for us. What did it actually let the government do?
Well, essentially, it meant the developers needed to get written permission from the Director of Lands before they could finalize the design, the layout, and critically the height of any buildings.
Ah, so the government kept a degree of control.
Exactly. And the justification, as seen in other cases like Crozet Limited, is that the government needs tools like this for proper urban planning. That includes things like traffic flow, aesthetics, and yes, aviation safety. It's about making sure development fits into the bigger picture.
Makes sense. You can't just have everyone building whatever they want, especially near a major airport.
Right. And interestingly, back in 1992, when the land grant was signed, there weren't specific laws capping building heights in Tsuen Wan because of the new airport. The existing height rules were mostly related to the old Kai Tak Airport's flight paths.
So no specific height law for Cheklap Kok yet, but the land grant did have limits on other things.
Yes, it definitely had limits on the total floor area you could build and the plot ratio, basically, how bulky the building could be relative to the land size.
And the developer's first idea, some residential towers, they weren't actually pushing those height limits initially.
No, their first outline plans showed towers around 172 meters. Those didn't seem to trigger these later aviation height concerns. The problems really started when the plans got much bigger.
Right, the height saga, as you called it. Let's get into that. How did we go from 172 meters to, well, aiming for the world's tallest?
The big shift came with their fourth outline development plan. That's when they proposed this huge 468-meter office tower, the one that became known as Nina Tower.
468 meters, that's a serious jump.
Huge! And this plan immediately hit a wall, but maybe not the one you'd expect first. It massively exceeded the floor area and plot ratio limits already set in the lease.
Ah, so before the height itself became the main fight, the plan was just too big overall, according to the original agreement.
Exactly. The government initially rejected it because it breached these fundamental lease conditions, too much floor space, issues with traffic arrangements. Height wasn't the primary reason cited at that very first rejection stage.
Interesting. So what happened then? Did they just give up?
Oh no. They went into negotiation mode. They tried to convince the government to allow a bigger plot ratio, sometimes offering things like public spaces or parks as a trade-off. There was a lot of lobbying, discussions with officials.
Standard developer playbook, maybe?
Pretty much. But then the aviation safety issue really came to the forefront.
This is where the Civil Aviation Department, the CAD, gets involved.
Yes. The CAD weighed in and said, look, because of the new airport's instrument landing system, buildings on this site shouldn't go above 324 meters above principal datum.
Okay, 324 meters. That's a massive cut from their 468-meter plan. How did the developers take that?
Not well. They pushed back hard. Their main argument was, hey, there's no law saying we can't build this high here. They basically felt the government was inventing a new rule just for them.
So they stuck to their guns.
They did. In fact, they submitted even more plans, the 6th and 7th versions, still proposing a super tall building. Get this, 468 meters plus a 70-meter spire on top.
Wow, 538 meters. So they were doubling down, really digging in their heels.
Absolutely. It shows just how committed they were to that world's tallest vision, even with the CAD raising serious safety concerns.
Okay, so that obviously leads us straight into the courtroom. What were the core arguments when this finally went to trial?
Well, the developers, represented by Jonathan Sumption QC, a major legal figure, argued that the government couldn't refuse approval just based on height, especially if the plans met all the other conditions in the land grant.
Their logic being, the lease doesn't say no tall buildings, so you can't stop us just for being tall.
Pretty much. They also leaned heavily on a case called Equitable Life Assurance Society v. Hyman.
Equitable life. How did that apply here, in their view?
They argued that the government using this DDH clause to suddenly impose a height limit went against their legitimate and reasonable expectations. They expected key commercial terms, like a height restriction, to be spelled out clearly in the contract from day one.
So they felt the government was sort of pulling a fast one, using a general clause to enforce a major restriction they hadn't agreed to up front.
Exactly. They saw the DDH clause as just procedural, like a checkbox exercise to make sure the design matched the other agreed terms, not a tool to introduce brand new substantive limits like height.
Makes sense from their perspective. But the Court of Final Appeal didn't buy it.
No, they didn't. Justice Bakri gave the main judgment, and the court firmly sided with the government.
Okay, so what was the court's reasoning? Why did they reject the developers' arguments?
The court looked at the DDH clause, Special Condition 9E, but read it together with other conditions. Specifically, one requiring height details in the plans submitted, SC5AI, and another giving the government really broad discretion in granting approvals, SC53B.
Ah, connecting the dots within the contract.
Right. The court said, when you read all these together, it's clear the Director of Lands did keep the power to control height. They disagreed that the DDH clause was just procedural. They saw it as giving real control.
And what about the equitable life argument? Did they address that comparison?
They did, and it's a crucial distinction. The court said, look, equitable life involved an insurance company and policyholders, a situation with fiduciary-like duties. Here, the government isn't acting like a trustee for the developers. It's acting as a landowner, looking out for the public interest.
And public interest includes?
Includes ensuring airport safety. The court basically said the discretion given in the lease was for the public good, and preventing potential hazards to aviation definitely falls under that.
So, public safety trumped the developer's expectation that height wouldn't be restricted unless explicitly stated.
That's the essence of it. The court also pointed out that these were experienced Hong Kong developers. They couldn't reasonably assume they had carte blanche to build to any height, especially when the lease required them to submit height details for approval, The very requirement implied oversight.
And the court also noted that this world's tallest building idea wasn't even there at the start, right?
Exactly. That came much later. The initial plan, those 172-meter residential towers, probably would have been fine with some tweaks. The whole height issue blew up only when they switched to the much, much taller commercial proposal.
So the dream met a regulatory reality check. Okay, now this whole back and forth took ages, right? And you mentioned that huge payment they made. Let's talk about the delays in the money.
Yeah, the timeline is important. All these plan submissions, rejections, negotiations, it dragged on. And meanwhile, the clock was ticking on those building covenants and the lease to deadlines to get things built.
Which they missed because they didn't have an approved plan.
Correct. So the government started demanding payments, assessed damages for the delay, particularly for completing a required transport terminus, and also a hefty premium to extend the building deadlines.
And that's the HKD 500 million plus figure we talked about earlier, paid to stop the government from just taking the land back.
Precisely. Paid under protest, always reserving their right to fight it legally. Now, the question of whether they could actually get that money back wasn't fully decided in this specific appeal judgment. That was set aside for potentially another trial.
But the court gave some hints.
It did. The court acknowledged the payment was made under duress, the very real threat of land resumption, and with that clear protest. They referenced another case, Maskell v. Horner, which suggests that money paid under such compulsion might be recoverable.
Interesting. So a loss on the main point about the height restriction, but maybe a path open on getting the money back.
Potentially, yes.
Yeah.
The financial saga wasn't completely finished by this ruling.
This whole case just throws up so many interesting ethical angles, doesn't it? Like balancing that drive for iconic development against public safety. Was the government right to block it, even without a specific law mentioning Check-Lapcock height limits back in '92?
It's the classic tension. You've got entrepreneurial spirit, ambition, wanting to make a mark, totally understandable. But the government's core job is protecting the public. A potential risk to a major international airport, even if not yet codified in a specific statute for that location, is something they arguably had to take seriously.
Yeah, you can see both sides. It highlights how regulations shape everything around us, sometimes limiting huge ambitions, sometimes protecting us in ways we don't even think about. It's that constant push and pull between what one person or company wants to achieve and what's needed for the community as a whole.
Absolutely. And it raises questions about clarity versus flexibility in rules. Do you need every single possibility spelled out in advance, or does the government need leeway to react to new situations like, well, building a giant airport?
So wrapping this up, what's the big takeaway from this deep dive? What's the key lesson here?
I think the core insight is how complex the interaction is between what a contract says, what regulatory powers the government holds, and this overarching need for public safety. The developer's vision was powerful, but it ran into the hard reality of major infrastructure needs. It shows that even broad contract terms get interpreted in context, and public interest often plays a deciding role. Unseen factors can really derail big plans.
Definitely food for thought. And maybe a final provocation for you, the listener. In a world that changes so fast, how do we strike that balance between encouraging bold innovation and managing risks we might not fully grasp at the start? Who carries the can when ambition clashes with these unforeseen necessities?
Were the developers pushing too hard, maybe not fully considering the ripple effects? Or was the government not clear enough early enough about potential limits? There aren't easy answers.
No, there really aren't. It's a fascinating case study in those competing pressures. What do you think? What stands out as the key conflict point here? Were the developers' expectations reasonable? Did the government handle it fairly? We'd love to hear your perspective. Let's keep the conversation going.